Number 159, People versus Lyxon, Chery.
May it please the Court, Marissa Cabrera on behalf of Mr. Chery, I'd like to reserve 2 minutes in rebuttal.
You may.
The Court erred in broadening Savage to permit impeachment by omission in this case of an unmirandized defendant, even though he never received the opportunity to narrate the essential facts of his case. Recently, in Williams and Pavone, this Court reaffirmed the rule that impeachment by omission is not allowed absent unusual circumstances.
The problem is, though, in Williams, we said that defendant's selective silence couldn't be used against him, but that was a case of direct examination, not cross-examination. That's really the distinction we're talking about here, aren't we?
Correct. I mean, Williams was in the case-in-chief in that case. The prosecution is in the case-in-chief. But Williams is helpful here because there was a discussion, a lengthy discussion of the law on this, where the Court, as Your Honor, where the Court discusses impeachment by omission as well, and specifically discusses
Savage and Rothschild.
And Rothschild, yes, which Rothschild isn't relevant here, but and respondent agrees on that. But in Williams, as reaffirmed in Pavone, it reaffirmed the principle that Savage is really the exception to the rule. And the rule is that impeachment by omission is just simply not allowed absent unusual circumstances, and Savage was one of those unusual circumstances. And if you look at...
So you're not asking us to overrule Savage, you just want to limit it to that. And can you talk a little bit about the interplay of Savage and Pavone?
Sure. I think with Savage, I mean, as Savage makes clear, you know, even if you look at the first sentence of Savage, it really goes through all the facts that the Court considered in the decision in determining that that was one of the unusual circumstances that would permit impeachment by omission. In that case, or in this case, in contrast to Savage, we have a pre-Miranda defendant. He was never given the opportunity to narrate the facts of his case.
Can't that work both ways, though? Because if he had been Mirandized, wouldn't he be more likely to remain silent than not?
Well, when you have the big distinction is that when you have a Mirandized defendant, they're on notice of their right to silence. They've decided to waive that right, and it generally then follows by an interrogation from detectives where they're being asked and offered the opportunity to discuss the facts of their case. That's just not what happened here, and Bornholt talks about that, getting the opportunity to specifically discuss the facts.
But here it was spontaneous. So, I mean, to me, it seems more likely that if it's spontaneous and he's wondering why he's being arrested and the other guy isn't, to talk about what the other guy did to him, and he just doesn't do that.
Well, there could be a whole host of reasons as to why he didn't come out with the most helpful fact at that moment. I mean, it could be, you know, here Mr. Chery is a non-native English speaker. You know, he quickly blurts out the first thing that comes to mind, just noting the general unfairness of the situation. There was other factors, though, and that's what Savage really explains that we have to consider to determine what exactly is an unnatural omission.
Can he say all that, though? In other words, if we say that you can't impeach him on it, the fear is that means that a defendant can make up anything he or she wants, you know, subsequent to the Mirandized, you know, remaining silent, and you can't cross-examine him on it. You can't ask him, you know, well, you didn't say that when you had the opportunity to.
Well,
and if you did say, as in this case, why not ask him, you know, why didn't you bring all this out, you know, when you were asked by the police? And he can explain, because I didn't want to say it or what. But to say you can't ask him, it seems to me, is almost, you know, encouraging perjury.
Well, it doesn't encourage perjury if he never actually had the opportunity to express his his side of the story. I mean, he was never sat down and asked what happened. He just on his own.
Well, suppose what he
learned-
said was untrue.
Okay.
Your argument is that the people can't cross-examine him about it, so this untrue story is going to be given to the jury untested.
But it's not that the statement, the purpose of impeachment of omission is not that the statement's untrue. It's that the omissions, or the new statement at trial is untrue. And so the omissions have to be deliberate when they're made.
But you see my point? Let's assume you don't, that's not your client. But if someone gets on the stand, having remained silent, but then tells this perjured story, your rule would say, well, the people just have to put up with that. You can't impeach him and say, why didn't you bring that out before, and ask him questions about, or her questions about, what they're now testifying.
No, we're not asking for a rule that broad. We're asking for we're asking, first off, really, that this court reaffirm Savage, the principles in Savage, where this court allowed impeachment by omission, actually. And we're really just asking that this court limit the rule so that impeachment of a defendant for omissions made during the course of a spontaneous statement are
But what
not
about the
allowed.
fact- Oh, I'm sorry.
My voice is almost gone, so it's my colleagues being deferential. Assuming we agree with you, and I'm not saying we will, but is this harmless error?
This error could not be deemed harmless at all. First, the evidence was just simply not overwhelming at all in this case, and I discussed that a lot in point 2 as well of my brief, dealing with the missing witness instruction. But there was a lot of factual disputes and contradictory testimony, and I can go through all of them, but one that was a significant one was the fact of the white envelope. That was supposedly the target of the search. And it was never vouchered. The officer, for the first time, discusses the white envelope at trial. It's not in the felony complaint either. And so, meanwhile, you have 2 other witnesses who say there was no white envelope.
Didn't the officer already testify to what the officer claimed he had said? So isn't that already before the jury, one version versus the other? Isn't the damage done to that extent? Obviously, I understand that
Yes.
people want to pursue this on cross,
Yes.
but isn't the information already out there? The jury's wondering, wow, you didn't say that.
Well,
They had you.
Well, the information is out there, but it's in this case, the prosecutor then in summation discusses the fact that he didn't, and it really just hammers home this principle
But this isn't
of,
taking it, we understand your point about how it can be used. I think that's what you're saying, and I understand that. But you look through the court's jurisprudence on this particular issue, it seems to me the key distinction is between the people going forward with, a defendant doesn't say something, and you're using, the people try to prove his guilt by something that he did not say, he or she did not say. That is a markedly different thing from a defendant coming forward and saying, this was my version of the events, and the people then challenge it on cross-examination. In Pavone, that was in cross-examination, and that's a plurality decision with no precedential value, because I think there was 5 of us, but we're 3-2 split on the legal applicability. In Savage, it's an older case, but as I remember Savage is also a cross-examination case. And it seems to me here we're faced with that same distinction again. And what you're asking us to do is to say something entirely different from the people not being able to use the proof directly in their own case by silence, by what you didn't say. That seems to be clearly constitutionally banned in any form, even selective silence, as we said in Williams. Entirely different from challenging your version of what happened with another version, or comparing the 2 of them.
well, the prosecution, if the prosecution were going to then, let's say on summation, present what Mr. Chery said to the officer, and then state immediately thereafter, this is what Mr. Chery stated on direct examination. That's permissible. We're not disputing that. What we are saying is that the prosecution can't then go into summation stating well, he didn't say this, he didn't say that, he didn't say any of this, he's lying, and not
But
just
when
lying, he perjured himself.
When he says, "I told the police officer that he had hit me with the board," for example, and then if, then there's impeachment saying, I mean, he never told me, or, about that. Why isn't that fair comment on the evidence then in summation?
Well, it's because I'm really more focused on the silence surrounding it. That was one specific fact.
When there's testimony about whether he did or didn't say it, that has to refer to silence, but how else, how...
Well, I think that's a very specific fact.
But isn't that what happened here?
Well, no, there were also other facts. For example, the girls running out of the store, and he said, no, I didn't say that. That's really more of what we're discussing. I think it is fair game if the defendant says, no, I did tell the officer that. Then the prosecutor can respond. But here, we're really more focused on the situations where our client testified that he did not inform the officer, and then the prosecution to then comment on that silence specifically.
Counsel, your time is up.
Thank you.
Thank you. Counsel?
May it please the Court, my name is Patricia Curran, and I represent the people on this appeal.
And counsel, I hate to interrupt you, but to start where we just ended here, on what I think is the scope, which is what's somewhat troubling to me. It seems our rule, and maybe I'm wrong on cross or direct, is to admit this type of testimony, you have to show that it was unnatural to omit certain facts from the statement. And his statement, as far as I can tell in this case, was, why isn't this other individual going to jail? He kicked my bike, he should go to jail. But the cross, as your opponent was just alluding to, is you didn't bring up that these two girls got thrown out of the store, and you didn't say, the owner said, get away from my store, and you didn't tell him he got hit with a wooden board, and you didn't tell him you saw him chasing girls out of the store. And it seems to me what the prosecution did here was use an excited utterance to open the door to you didn't do, which to me does not seem to be the purpose of this narrow exception to using silence. So if in this statement that the defendant made, there was something, or as what Judge Stein was saying, it's a contradictory implication, but if there was something necessarily omitted from that anyone, even in an excited utterance, would say, then you can cross on that. But it doesn't open the door for a laundry list of, from one excited utterance to a laundry list of, but you didn't say, but you didn't say, but you didn't say.
Well, Your Honor, the focus of Savage is on the unnatural nature of the omission here.
Right.
What the defendant said at the scene was, when they were unhandcuffing the victim and leaving him handcuffed, why aren't you arresting him too? He kicked my bike.
Why isn't he going to jail? He kicked my bike. He should go to jail.
Why aren't they arresting him too?
Right.
He kicked my bike.
Right.
Now, at trial, he then testifies, not only did the victim kick his bike, but the victim also attacked him with a wooden board, hit him multiple times.
Why is that,
and
counsel,
then,
why is that so unnatural if the way that the defendant saw this event unfolding was that it started with the victim kicking his bike, and that was the first thing that came out of his mouth.
And
This started because he kicked my bike, and then these other things happened,
Your Honor, this defendant could say whatever he wanted to at this point. He chose to stop his statement, saying only the piece about the bike, and then at trial, talking about the very vicious and brutal attack.
But
he
isn't
claimed
that
he had to
exactly the problem with the silence, with this issue about using the silence and omission, these partial silence or full omissions? There are a variety of reasons why someone might not speak. And what one person might see as what you're suggesting is this is unnatural under these circumstances, might be, as you're hearing from other people, certainly Judge Garcia, maybe it's not so unnatural, given the circumstances, as Judge Abdul-Salam is suggesting. And that's in part the problem with allowing the use of the silence.
You mean as opposed to what the court found in Williams and Pavone? Right, and Williams and Pavone are obviously very different. In Williams, the people affirmatively used the defendant's silence as affirmative use of his guilt. That's not the case here. In this case, and by the way, in Williams, the defendant doesn't testify. They bring this all out through the officer. That's very key also. Here, the Savage exception is focused totally on cross-examination if the defendant testifies, not on putting forth affirmative evidence of guilt.
The idea
And
of that is, in Savage, that what the defendant said, it's unnatural under those circumstances for him to have omitted to say X and Y. So I think you have to look at what the defendant said and then say, was it unnatural for them to say X and Y? And here, he makes this spontaneous statement. It's not a 30-page confession that he says, I'm not talking anymore, which is essentially, why isn't that guy going to jail? He kicked my bike, which opens the door, apparently, to why didn't you say he chased women out of the store earlier? There's no logic in that to me. There's no reasonable relationship between the questions that were asked and what might be considered an unnatural omission under the circumstances and the substance of what the statement, was made in the substance of the statement.
The number of questions that the prosecutor asks is because the defendant puts on a fairly lengthy story about what happened.
Right, and you certainly, I think as was pointed out, could get up in summation and say, here's what we heard at the time of the arrest. Did you hear this? That's argument. Maybe they would object, maybe they wouldn't. This is, you're using a specific and limited exception to use silence to cross-examine a defendant who made a specific statement, and it's an excited utterance, pretty much, and you're using that to open the door to say, why didn't you say these 10 things also? It just seems like that isn't logical application of the rule in Savage.
Under Savage, obviously the court thinks, and we obviously believe the same, that this was an unnatural omission. And getting back to something that Judge Rivera brought up, the defendant could have offered why he didn't say these things. It really goes to the weight of the evidence, not the admissibility. He could have said, well, I don't trust police officers, or I didn't get a chance to say anything.
That's assuming you get to ask it. But the question is, do you get to ask it originally, so he has to explain it that way? And my problem is with, do you get to ask it?
Certainly in the facts in Savage, the court found that what the defendant had omitted to say was significantly unnatural. And
Does it matter that the statement, sentences that you're referring to are inculpating someone else without an attempt to exculpate himself? And he's not saying, don't arrest me, arrest that person.
well,
Or did I misunderstand the statement?
I think that the statement defendant said here was both. He was trying to exculpate himself
Well, how's
by
that?
inculpating the victim.
Isn't he saying to, as in T-O-O,
Yes.
as in
Yes.
that person should be treated the same, as opposed to I should not be treated this way, only they should be treated
Yes.
this way?
He says, why aren't you arresting him too?
Two.
He kicked my
So
bike.
he's not asking at that point, don't arrest me, saying you should arrest them too. So in any event, assume that my point is correct in the way one would interpret that. Does that matter for purposes of this analysis?
Matter whether it's not
It's-
incriminating at the time.
Correct.
No.
Not an exculpatory statement.
No, we believe that it doesn't, and by the way, the defendant didn't preserve that argument. But there's no reason why an unnatural omission has to be focused or stem from an initially incriminating statement. The defendant could have said anything he wants. The focus is whether it's unnatural.
And that gets back to why people might be silent or say things.
I'm sorry?
That goes back to why people might be silent or say things or say only part of things, not fully appreciating what you have just argued, which is something that doesn't on its face incriminate you, is nevertheless something that may suggest you're not credible and reliable and that you are fabricating your statement, your story, because that's Savage, right? You're trying to fabricate, so you're just not reliable and credible.
But the defendant had the opportunity to offer those suggestions.
But we're back
if
to
he
Judge
wanted
Garcia's point, which is
Well-
you first got to make the case for why you should be asked initially, before you say, now the burden is on you to explain yourself.
But the court and the defendant is not asking that this court overrule Savage. It's simply a matter of whether the court believes this is unnatural. The court
Savage was
below-
a pretty lengthy post-arrest statement with details of the crime, and the cross was what was omitted from that statement in the course of a pretty lengthy narrative, tied to what normally would have been in, I'm presuming from how they describe it, a pages-long confession, or at least a lengthy and detailed confession. I think the problem here is you have almost an excited utterance, and you want to use it like a Savage statement. And it seems to me the exception should be tied to the specific statement that was made, not the Savage rule applies because you made a statement and something's not in it.
But in this case, Your Honor, the defendant poses the question to himself, which is, officers, why aren't you arresting him too? And then he gives his answer. And the answer, it turns out, we find out at trial, was not complete. He focused his own attention
Well, he's
on...
handcuffed to the tree or wherever you had him. But, so, to get beyond that, because I think time is running out, do you want to address the harmless error point?
Certainly. Obviously, we believe that the admission or the questions here were harmless. The jury already had heard from the police officer what the defendant had said about the victim kicking his bike. When they then heard what the defendant said later as to what had transpired, I think as one of the judges already said, the cat was already out of the bag. The evidence here was overwhelming. The defendant was arrested at the scene. There was no question of identity. The two weapons used during the robbery are found, the wooden plank and the piece of metal, on the ground, and he has the robbery proceeds in his possession.
Ms. Curran, do you care to address the legal sufficiency argument that's been raised here on physical injury?
The physical injury point?
Yes.
First, I want to point out that the defendant was also convicted of first-degree robbery, so whatever the court should find as to physical injury doesn't matter, but there was plainly physical injury here. This victim had a cut to his hand, he had extensive bruisings to his back and his legs. Chittick tells us, this court's decision in Chittick tells us to look at the way in which the injuries were inflicted. Here, the defendant's unapprehended accomplice used the wooden board to hit the victim several times. He testified that he experienced pain for approximately 10 days, though not all 10 days.
If all you had was his testimony about his subjective experience, would that be enough?
I think it would be, but that's not the case here because you have other witnesses testifying about some of his injuries. Obviously, the ones on his back and the ones in his clothing were hidden from view, and I know the defense makes a big argument about the fact that he didn't go to the hospital, but he explained that. He didn't have insurance, and he couldn't pay for that. And I also would like to point out that these kinds of injuries are not the kinds of injuries that he would have necessarily needed medical treatment for. They were bruises and a cut to the hand.
Thank you.
So we believe that the court correctly found sufficiency here. Thank you very much.
Thank you. Ms. Cabrera. Ms. Cabrera, if one were to think that Mr. Chery were trying to exculpate himself at the scene, wouldn't it be most natural for him to lead with the strongest fact that he thought he had, which was somebody's beating me with a piece of wood rather than someone's kicking my bicycle?
Well, no. First, there could be many reasons as to why, as I mentioned earlier, as to why somebody may not provide the most exculpatory statement at that given moment. But it's also just not, the determination as to what is an unnatural omission is just simply not as to whether or not more mitigating facts exist out there. Savage makes clear what else we should be considering. And I'd also like to note, in terms of the excited utterance analogy here, and because, as Judge Garcia noted, this is pretty much an excited utterances are reliable for their truthfulness, and that's why they're allowed in, not because of their completeness. And I think that's important because that's what we're dealing with here. We're dealing with, was his statement sufficiently complete?
Well, he testified. I mean, you don't need an excited utterance to get it in if he's testifying himself.
Oh, yes, no, I mean, we're not, of course, but it's really more just to analogize it. And I think here we have a situation where Mr. Chery just simply blurted out quickly the first thing that came to his mind, as Judge Abdus-Salam noted, the initial interaction that one of the earlier interactions that they had, and that's what, to then hold it against him later on at trial when he was never sat down, asked, and interrogated about it, is just simply unfair. And so, for that, we would ask that Your Honors reverse the judgment of conviction and order a new trial.
Thank you.
Thank you, Your Honors.